In a recent case, the Appellate Division of the 3rd Department, which is an appeals court, held that a family court judge granting a father custody of his biological child and a child he was not biologically related to could be done. A father and mother were married. They lived together with 2 children. The father was the biological father of one child, but not biologically related to the older child. They entered into a separation agreement. Under the terms of that agreement, they agreed to have joint custody of both children with physical custody of the children to the mother. The father had parented with the children. The mother thereafter consented to a finding of neglect involving her and both children. The court took into consideration in its decision that the non-biological child had lived with the father and was maintained by the father on a regular basis. The father, in his proceeding, sought to modify the visitation concerning both of the children. In his modification petitions to the family court, he asked for sole custody now of both the children. Before there was joint custody. The family court initially entered into an order granting him physical custody of both children and granting the mother parenting time. Thereafter, the mother brought a petition involving visitation to the family court. The family court granted in this petition residential custody of both children to the father and gave the mother liberal visitation. The mother appealed the last court order. The appeals court held there was a sound, substantial basis for the family court awarding custody of the children to the father. They took this position because the father was providing a more stable home and he had shown that he was capable of taking care of both of the children's needs. My conclusion on this case is that it is possible for fathers to gain custody of both children they are biologically related to and not biologically related to. This is a case of first impression.